Turn to M3 and Karen B for this week's episode of Comply on the Fly. You'll get quick and timely answers to the most common employee benefits compliance questions so you and your business can keep moving ahead. Please note this podcast and the contents herein do not constitute legal advice. Please seek the advice of counsel for any benefit compliance-related implementation, guidance, or strategy.
Hello, everyone. I'm Karen B. And the Comply on the Fly question of the week is, I forgot to provide the COBRA election paperwork to a terminated employee several months ago. What should I do? Well, the first thing that comes to my mind is taking a look at your COBRA process. Whether you are outsourcing and need to communicate COBRA qualifying events to a third-party administrator or you self-administer COBRA, it would probably be a good idea to figure out what went wrong, what broke down in your process, and fix it going forward. But what can you do about those missed election notices? Once discovered, you should immediately take steps to correct. Why? Because you have exposure to some significant consequences. IRS excise tax penalties, ERISA statutory penalties of up to $110 a day, potential lawsuits, and potential issues with insurance carriers if fully insured, or stop-loss carriers if you are self-funded. So, if you discover this problem, it is a good idea to send the notice as soon as discovered. Of course, if the amount of time that has transpired since the COBRA qualifying event is relatively short, say less than 60 days, the possibility of there being any issues is less than if several months have gone by. If several months have gone by, when would COBRA coverage begin? Well, it could be offered retroactively to the date of the COBRA qualifying event. That must be made very clear in the paperwork you send, or the COBRA qualified beneficiary may assume it is an offer for prospective coverage. And remember that a retroactive offer means the COBRA qualified beneficiary would be electing back to the original COBRA qualifying event date and would have to pay premium for all those months, even if no medical expenses in certain subsequent months were incurred. However, what if the notice is really late? Then you may want to consider a prospective offer, but this would need to be vetted with your insurance company, if you're fully insured, or your stop-loss carrier and your benefits counsel. And that is your Comply on the Fly question of the week. Thanks for tuning in.
What's on your mind? If you have a pressing compliance question, send it to askkarenb@m3ins.com. We'll do our best to cover it in an upcoming episode. You can now follow and subscribe to Comply on the Fly on Spotify, iTunes, and Google Podcasts. Make sure to tune in next week and encourage others to join us.